go on to the value of the policy to protect the reputation. Obviously, a reputation of a professional service firm is its major asset. The people who work there and the reputation that is built over the years is what really gives firms value. And I think there's some policy enhancements that really can assist our policyholders in protecting their reputations.
Yeah, so I guess I want to highlight a little bit of what we have currently and then what we're adding into it as well. So the risk mitigation deductible credit, and actually there's a companion piece for firms in our small firm and our middle market segment of a premium credit as well. But the risk mitigation deductible credit essentially states what we feel to be best practices in the industry that, if followed by the firm, will either lead over a long period of time to a diminution of claims or perhaps preventing a claim, but at the very least, once a claim is presented, the carrier and the client's in a better position to defend themselves to an amicable and solid resolution. So that is not changing in the new form and will continue to be there. But we felt that in companion with that, there's also an opportunity to address the fact of early resolution. So in this particular item, we are adding a separate deductible credit that could apply if a claim is resolved within a period of time. And this is not the element to say that every claim should be resolved. As a matter of fact, every claim should not be resolved. But in the case where there is a natural progression of either recognition of actual negligence, and we just need to move forward with resolution of the claim amicable to the owner, or it's a situation that allows us to use maybe mediation or some other technique to get to a better result, this then provides a little bit of incentive to the client to resolve that case.
And I think the CNA claims specialists have long favored good faith negotiation and, when necessary, facilitated negotiation or mediation to solve disputes. And much of that is simply to protect the reputation of the firm. You don't want litigation. You don't want the bad PR that goes with that. You don't want the lengthy battles that could happen. And you don't want to end up paying lawyers more than you have to. So I think that early resolution reduction in the deductible obligation is a good way to encourage firms to resolve disputes as quickly and as quietly as possible. Now, tell me about this crisis event. I mean, I know we've seen many firms victimized over the years by bad press or misinterpreted information about a firm's role on a project or what the actual problem is that's developed on a project. It appears that the policy now provides some support for getting the story straight. So let's talk about the crisis event.
Yeah, and I would say crisis event coverage is not unique to this policy, but it is available in different industries across the area depending upon what they do, advertising and other aspects of groups. Crisis event expense or crisis event coverage is something that's available in the industry. Specifically for architects and engineers, what this does is address the fact that you could have a situation happening within the business that could lead to a diminution of value of the firm, loss of business, or other aspect. And as Frank said, getting the story right. By engaging a public relations firm, we might be able to offset that negativity to help you in a crisis situation, something that happens dramatically and we need to react to it now. So the policy going forward will pay 50%, which is be a shared cost basis with the other insured, with the insured, for $30,000 for one event, up to $50,000 during the policy year. There is a time limit involved there, roughly about 6 months, that recognizes the fact that at some time a crisis is no longer a crisis. And this coverage is designed to help get you through that initial process. What's, I think, fairly unique about this coverage is the breadth of activities that could happen that would allow you to evidence this coverage. So in a very basic standpoint, you could have death of or serious illness of an individual that could lead to bad press or things that happen. But also two elements. One, workplace violence. The simple act of workplace violence in your building or location could result in crisis event. And we're subject to coverage here. Not to say that we would that would ever happen to anybody in the architect and engineer industry, but we see it on the news all the time that those things occur. So that's an opportunity to get crisis event coverage. More importantly, the simple act of a wrongful act, a claim under the policy, could exercise crisis event coverage. And we've seen that in the industry over many years where on a particular project you had a situation with a lot of unique pieces that essentially the owner, although he was maybe a little overstretched and couldn't complete the project, decided to fire the architect. And not only fire the architect, but decided to go to the newspapers and tell them all the reasons why he fired the architect. And what you have is not only a subsequent claim for improper design and other aspects on that project that led to the firing and the responsive counterclaim from the architect, but also the fact that you've got the newspaper battling on this issue. The simple act of that claim could trigger a crisis event coverage so that you're dealing with it at both times, not only defending the claim, but also addressing the reputation and what's going on around the industry.
And I think we've seen this happen with sustainability issues where a firm is identified in the press as not designing something that really saves the amount of energy that was expected, and all of a sudden the reputation of that firm really is challenged by some reporting that may not have any basis in fact. So, I think this is a great addition to the coverage in SAFE.